Welcome again to Marquette University Law School, the Lubar Center at Eckstein Hall. I'm Mike Gousha, and this is On the Issues. This is our continuing series of conversations with news and policymakers, people we like to say are doing interesting, important work in this region and beyond. Today, we are joined by the authors of this new book. The book is called The Constitution in Jeopardy, an unprecedented effort to rewrite our fundamental law and what we can do about it. The authors of that book are seated next to me. On my far left is Peter Prindiville. Peter is a non-resident fellow at the Stanford Constitutional Law Center and an attorney based in Washington. Previously, he was a fellow on the Senate Judiciary Committee, and he tells me he was also at one time a high school history and civics teacher in Biloxi, Mississippi. Seated next to me is a man who, that's fine, feel free. Seated next to me is a man who probably doesn't need an introduction to this audience, but I'll give him a brief one anyhow. It is former U.S. Senator Russ Feingold. He served the people of Wisconsin in the U.S. Senate for nearly 2 decades. He is currently the president of the American Constitution Society. He is the recipient of the John F. Kennedy Profiling Courage Award. And he's the author of the best-selling book, which was really a terrific book called While America Sleeps. But what makes him near and dear to Marquette Law School is the fact that he used to teach here about a little over a decade ago.
That's right.
And so we are delighted to have him back. So please give him a warm welcome. Two thank yous before we get underway. First of all, thanks to our good friends at Boswell Books, the independent East Side bookstore. They are in the lobby today. They're a co-sponsor of this event, and in the lobby today where they will be selling copies of this brand new book, hot off the presses today. And also want to thank our new friends at C-SPAN who are here recording this event for later broadcasts. So having said that, let's delve right into the book. And I'm going to begin with a question for Peter Prindiville. Tell us about the origins of the Constitution in Jeopardy, because according to the book, this was your idea. Why did you think the topic was timely? Why did you think it was important?
Well, Russ was teaching a course on Article 5 at Stanford, and I was fortunate to be in the course my first year, and then joined him as a teaching assistant during my second year. And Russ had taken a new position as president of the American Constitution Society, and through our conversations towards the end of the course, I thought to myself, this topic is so important, and there are a few people who have thought about it so much and have had such a fantastic career thinking about these important civic issues. And so I sent him an email late one night and said, hey, I really think you should write a book about this, and it just flowed from there.
So. What was your reaction when he sent you the email?
I said, look, it's COVID. We're teaching, remotely to Stanford students. I just took this new important job. If we're going to do it, you're doing it with me. And so that's how it happened.
So Article 5, we're talking about the process by which we amend the Constitution. You say in this book, the two of you say in this book, that we are the Constitution is at a precarious moment, and it faces twin jeopardies. What do you mean by that, Senator?
Well, as we were getting ready to really get this book going, thanks to Dean Kearney and Marquette Law School, we were able to use the resources of this great library in this facility. And he was very kind in saying that we could do that, but the dean is not known as a melodramatic person by any means. I think that's fair to say, right? But he wrote at the end of this letter, he said, an Article 5 convention, yikes. And that, in some way, says it all. It is something that is potentially dangerous. It is something that could involve rewriting the Constitution by very far-right groups. And it's something that we want to warn people about. That's one jeopardy. The other jeopardy is that we really have a constitutional amendment mechanism that almost doesn't work at all. We've only had 17 amendments to the United States Constitution since the Bill of Rights in the whole history of this country. There hasn't been a new amendment passed for 50 years. There was one that was approved that went back to James Madison. Don't get us going on that. But literally, when I was in high school, the 18-year-old vote. So this mechanism is so hard that it doesn't really work. And so we talk about that as causing, almost the ossification of the Constitution. So there's two different problems. One is you change it in a way that is a far-right fantasy. The other is that you can't change it at all. and you don't fix things. So I think that's kind of what we mean by this.
So Peter, explain for us, there are obviously a fair number of lawyers in this room, there are law school students, but there are people who are not lawyers. Explain to us how you can amend the Constitution. There's really a couple of different ways.
Right, so there's two methods for amendments to be proposed. The first is by Congress, approval by 2/3 of each house of the Congress. And there's also a second method for amendment proposal, which is the focus primarily in the book, which is a convention. We've never held a convention to propose amendments, but that really is the focus of this current movement, and like I said, is the focus of the book. After amendments are proposed, either by Congress or a convention, they then are sent to the people of the states for ratification. Article 5 contemplates that ratification can occur in two ways. One is through the state legislatures, one particular forum, or the Congress can provide that amendments are ratified in state ratifying conventions, which has occurred just once.
And both require 3/4 of the states.
Yeah, and those supermajorities, isn't that the argument that because you would require supermajorities to amend the Constitution, that this is not likely to happen, that this is sort of Article 5 is almost dead or useless in today's modern era?
That's sort of the comfort that people, particularly on the progressive side, give each other. Say, well, they might have a convention and propose this stuff, but not to worry, 3/4 of the states. But the fact is that 34 states can call this convention. That's 2/3. And they can call a convention, and they can propose whatever they want, and then that's going to be done potentially just by a majority vote at those conventions. We think they're going to set it up, or try to set it up, so each state gets one vote. In other words, the Electoral College on steroids. So they can just pass anything by majority vote. Make sure the EPA doesn't exist, majority vote. Then they send it, then it has to be sent to the states, so people say, well, it's going to take 3/4. Well, the difference between 2/3 and 3/4 is 34 to 38. It's just 4 more states. So I think people are a little overconfident about that.
The other element is that unlike bills in Congress that expire if they're not approved by the end of the session, amendments can stay alive for forever. It's possible that amendments proposed by a convention could remain dormant for a century until efforts are rekindled to ratify them. And I mean, that's the story of recent experience. I mean, our most recent amendment, which was ratified in 1992, was proposed in the late 18th century. And so there's no reason to look at this as the next 3 years. It's really could be a decades and even a generational concern.
The fact that we have not had a constitutional convention seems to give some people comfort, or it makes them see this as a less important, a less pressing issue. But in the book, the two of you write that there have been events in modern history that should make us stop and pause and say, well, is this so far-fetched after all?
It's not far-fetched. It came very close in the progressive era when the Congress became so nervous about the proposal to overturn the ban on the income tax by the Supreme Court, and in particular, the people wanting to have senators directly elected rather than chosen by legislatures. They decided to, just before they got enough to act. And then there were 2 other incidents. In the 60s, Everett Dirksen, former senator from your state, not our state, came very close and suddenly died, but they were very close to having a constitutional convention that was to overturn the reapportionment, the malapportionment decisions. And then in the 80s, in 87, they came extremely close after Howard Jarvis, Proposition 13 in California. They wanted to go national with the balanced budget amendment. So all of them, I think, right, Peter, they came within 1 or 2 states.
And we call it in the book the near-miss moments. There's a tradition. Every few generations or so, there's a historical phenomenon of movements to awaken the convention route, Article 5's convention route. There's often rapid movement that occurs off the front pages with little opposition. And you reach these moments of a crescendo moment. People wake up, they realize the danger, and there's a slow retreat from the ledge. And that is a historical phenomenon that we're worried about, and we're seeing it gaining steam again.
In the book, you write about efforts to have a constitutional convention. You say they've been going on for a couple of decades now. Is that correct?
Yeah, it depends what you want to trace it back to, but I actually included a picture of Chief Justice Horace Wilkie of Wisconsin giving a speech in my home county, Rock County, condemning the idea in 1963, just before President Kennedy was killed, of something called the Court of the Union, where they were going to create a national court of the states that could overrule the Supreme Court. So this kind of thing was already there, but as we write in the book, it kind of, as Peter was saying, kind of goes in fits and starts, but it's essentially the same thread. And the thread is they want to basically cripple the federal government. They basically want to weaken it to the point where you may not have environmental regulation. You may not have voting rights. You may not have workers' rights, worker protection rights, that they want to really gut the federal government, and that's been their goal throughout this process. And now they've figured out a way to do this that is sort of under the radar, quietly trying to do this convention, and they want to suddenly jump to it.
You say they. Who is they? Who are we talking about? Who's in favor of a constitutional convention?
Well, there's a number of groups, and they operate under different banners. But as we argue in the book, it's prudent for citizens to consider them all similar in their aims, because if a convention is called, it can't be limited to a particular topic. So the aims of the group are somewhat immaterial. But there's one group called Convention of States Action. They have proposed, I think now they claim that 19 applications have been passed, including Wisconsin. There's another group aiming only for term limits for Congress, and another group that really is the modern day movement from the balanced budget era movements from the 80s. And they are rekindling some of the applications that were actually passed in the 80s and trying to add them together to get to the magic number.
Who is funding the effort based on your research?
Well, you can think of the Mercers and the Koch brothers, and has two examples. If those names ring a bell, they have been heavy funders.
And the movement is very well funded and operates in a lot of forms of legal organization where it's actually challenging to see who their donors are and how much money that they're taking in.
Prominent political figures today. Who supports a constitutional convention?
Well, your former governor, Scott Walker, works for these folks. Rick Santorum is working for them. In fact, my wife and my brother-in-law went down and saw a rally with those folks. DeSantis has endorsed it. Marco Rubio. And it's actually becoming, as we were talking earlier, one of these things that these very conservative people have to prove that they'll support so as to not run crossways with the very conservative electorate.
The Republican Party of Texas just included it this year in their official party platform to call a convention. So it really is becoming enmeshed in kind of the agenda of the modern far right.
Peter tells a story about the Cheney. That's a great example.
Well, I was watching a video on Twitter of protesters at an anti-Liz Cheney rally in Wyoming, and I was surprised. I sent the video right to Russ because almost everyone in the video was wearing a pro-constitutional convention lapel pin, and to me it was just emblematic of where we are as a country and how this issue has become part of a litmus test on the right.
You referred to this, Senator, earlier about the fact that sometimes people on the left or progressives do not take this seriously. And they seem to feel that, I think the word you use, is they feel this is one of the archaics of the Constitution. Article 5 is one of the archaics of the Constitution. You and Peter make an argument in the book that for people who think that, same thing was said about the Second Amendment not all that long ago, that it was one of the archaics.
Well, when I was an undergraduate at Madison, I took constitutional law undergraduate, and the professor was a great professor, and he said, the Bill of Rights is being applied to the states by the Supreme Court. And I said, Professor, what about the Second Amendment, the right to bear arms? And he said, well, that's just for the government. And I said, wait a minute, the Bill of Rights wasn't for the government, it was the opposite. So I wrote my thesis on this, just saying, I'm concerned that this thing is not being taken seriously, and I didn't want it to be taken as seriously as it has been. But you know, the far right is very good at that long-term plan, and now it's the law of the land that an individual right to bear arms. So the term I used then, and I didn't realize I had, but we use it now, is the archaics, the conscious willingness to sort of look at something and say, well, that thing's never going to matter. And of course, part of the problem is that there never has been a constitutional convention. Mm-hmm. So it's understandable that people, if they don't know the mechanics of it and what's going on, would say, well, why worry about it? But we're here to say it's happening and you better worry about it.
The text remains in the Constitution. It's never been struck. And thus it's important to take it seriously, understand its potential and also its risks.
I mean, the point is, that point is very important, which is, this isn't January 6th. This is legal. This is the law of the land.
Inherent legitimacy. And that, I think, is why, you know, the book is, I think in the front cover we say a warning and a way forward. And that the core thesis of the book is to begin a civic discussion about Article 5 itself, both these dangers and the potential, because it's not an archaic, and nor should it be an archaic.
I want to spend a couple more minutes on the planning that you say is taking place right now to hold a constitutional convention. In the book, you cite something that happened in Virginia back in 2016. Tell us about that.
Well, it was a mock convention. And apparently there had been an earlier one in 2013 that had some bugs in it, but they held a real convention. Yes, it started off with people in George Washington outfits and so on and so forth.
So it was immediately dismissed as, oh, it's a bunch of
sort of the media said it was a funny thing. But as we write in the book, it was very sophisticated. They took serious arguments, they had committees, they took votes. These people, many of them state legislators, are being groomed and prepared to be the delegates. And we're standing around going, those of us in our viewpoint, we're just looking at this and saying, well, will this ever happen? So they're in heavy preparation, and I think they just had another gathering.
Just last year, I think. The real trouble with this, and I think it's why we focused on it in the book, is it wasn't a costume party. I mean, these are a convention's never been held, and how it occurs in reality is incredibly important. The rules that are put in place, what are the parliamentary rules? How are delegations selected? That's not clear from the Constitution, yet now there is a truth that is being written on the right about all of these myriad unanswered questions. There's now a right answer, and it's being put into play in these mock conventions. But there is no certain answer. The constitutional text doesn't answer the questions. Relevant history doesn't answer the questions. So they're very much topics on which there should be robust civic and academic debate. But these efforts on the right is to engineer an entire way of conceiving of Article 5 that is advantageous to certain interests.
One of the concerns that you discuss in the book is the prospect of if you were to have a constitutional convention, that's still a big if you were to have a constitutional convention, it could be a runaway convention, where it would not be focused on a narrow topic like term limits or a balanced budget amendment, but it would go well beyond that. What concerns you so much about this possibility?
But we don't see anything in the text of the Constitution and Article 5 or in scholarship on this and our look at it to believe that there is any way to constitutionally limit a convention. If it is called, and Congress is required to call it, if there are 34 states, the delegates are there. And they get to make it's an institution by itself. They get to make their own decisions, and they get to decide that it takes 26 out of 50 state delegations that they want it to be to put something forward. And so
some people claim that.
But this is what we know this is what they'll do.
Right.
Because at the training, this is how they do it. Critical point here is I once did a talk, participated in a program at Stanford Law School about aspects of this. And I referred to it as a convention to propose amendments. And one of the very conservative scholars got up and said, "Senator, you're wrong. It's a convention of the states." Well, it doesn't say that anywhere. It's not a convention of the states. It says 34 states can call a convention, and Congress calls the convention. It's not a convention of states, and so our view is that if it was done properly, of course, it would be representative and people would be involved at a popular level. It wouldn't be one vote per state, but this is a critical part of their strategy, and it's how they make it run away, is that you just need 26 votes, and you can throw anything in there.
You've called it the prospect of a wonky runaway is the most concerning. What do you mean by a wonky runaway?
Well, it's common, this idea of a runaway convention has been, it's not a new argument. This was raised during the Progressive era. It was raised during the Dirksen era in the 60s, raised again during the balanced budget movement in the 80s, which at base is a sign that it's a real concern if it's been shared by many across many political and ideological persuasions over more than a century. But oftentimes the runaway is framed in the public mind and in the public square as quite brazen in its redrafting. Getting rid of Congress as we know it, or instituting parliamentary forms of government, or what some might conceive as quite radical changes. And our position is that the real fear it's the runaway of a lawyer. It's not the runaway of a revolutionary. It's a runaway that many might not even see coming. Proposals that are drafted are surgically drafted to address wonky legal doctrines like federalism and judicial authority that in their application will have a profound sea change effect on government and modern life, but will be hard to maybe even foresee in the moment. And that's the real fear. And even by, we say that, a constitution or a convention can't be limited. But even if you read the applications that are being passed by legislatures, their purported limitations are so broad that any of these kinds of more wonky proposals would be germane, even if you believed that a convention had to be limited.
You talk about what can be said or what can't be said in these various applications, but it is, in fact, can be so broad. It could be something as generic as limiting the jurisdiction of the federal government. Consider amendments that would do that.
That's essentially what this Convention of the States group is proposing.
So then everything is pretty much on the table.
Pretty much.
Most everything is on the table.
There's one technicality in the Constitution that I taught my students, which is the one thing you can't amend under Article 5 is the equal representation in the Senate. You can get rid of the president, you can get rid of the Supreme Court, but you can't do that. So we propose actually that Article 5 be amended and changed. But that's literally the only thing that is unamendable in the current United States Constitution. So it's all fair game.
Doesn't that have appeal to let's face it, there are probably a lot of people in America would say, a constitutional convention that would limit the power of the federal government, count me in. I'm on board with that. Isn't that part of the concern too?
I think so. I mean, it's such a broad claim, and I think it can be hard for people to see what that would look like in practice. I mean, what does it mean to limit the power of the federal government? But you're right, it has a certain ring to it. And I think that's why this movement is achieving such success in state houses. It's pretty remarkable, the rapid fire growth. But our position is that people need to think seriously about the implications, both politically and legally, of such an agenda. And anything could fit into that ambit. I mean, you could propose an amendment that eliminated the jurisdiction of federal courts to hear civil rights claims. So and thus you eliminate 7 decades of civil rights jurisprudence.
Overwrite the Voting Rights Act.
I mean, it's
prohibit climate change or EPA regulation. It's all something they could write in the Constitution.
It's so broad that really anything could fit.
But conservatives argue you're just being alarmist, that this is, you're playing the fear card here, that you're trying to get people amped up about something that is not going to happen.
Yeah, I mean, as alarmist as those people that said that Trump could get elected. I mean, at some point, people have to wake up and realize, and Peter made this point, this is a coalition of people that are operating with huge funding to do everything from creating this independent state legislature philosophy that the Supreme Court's going to consider, where even if the Wisconsin Supreme Court said that Joe Biden had won the election, the legislature could vote and say no. Same people. People behind January 6th. People behind what's happened with the Supreme Court. For people to say that's not going to happen, they're not learning the lessons of what's going on in this country, which is quite disturbing.
So to have a constitutional convention, you really have to look at the numbers. You have to look at math. You need 34 states to file applications. Where are we at this moment in time? I know there may be different answers from different people, but where do you think we are?
Well, it's hard to say, and ultimately we believe that Congress. It's clear from the constitutional text that the power to call a convention resides in Congress. And so Congress really, at the end of the day, decides how these applications are counted. So although it might appear to be, almost a bureaucratic task, gathering the applications, counting them up, 34, we call a convention, it's actually quite political. And how there's a myriad of open questions about how that counting is actually done. Can applications be counted if they have a subject matter limitation, even though a convention likely can't be limited by a subject matter? There's a new theory that's been proposed in the last few years that certain applications passed in history, some in 1789, others around the Civil War.
New York State, right?
Right.
And Illinois.
And Illinois. I believe the Illinois state legislature has actually since rescinded that.
Okay.
That's an open question. Can they be rescinded? But assuming they can these applications from history be used with current efforts? And we make a fairly legal argument in the book that they can't be, but that shows you where things are. We call it mathematical magic. There's this new effort to, the goal is 34, how can we get there?
And if you don't think they're going to do it, I mean, again, because you were able with the Cheney story, a few weeks ago, Representative Jody Arrington of Texas introduced a resolution calling for Congress to acknowledge that there have been enough states that have done this with regard to the balanced budget amendment. And he said they should have done it a long time ago. So what do you think is going to happen if the Republicans take over the House? I mean, this is a body with 128 people who don't even admit that Biden won the election. They're not going to care about whether they count right or count wrong.
Right.
They're just going to do it. And the Supreme Court probably wouldn't touch it. A, because it's this Supreme Court, and B, because it really has nothing to do with the Supreme Courts. There's really no law. The founders didn't leave us with any real rules. If you pass a constitutional amendment through Congress, there's clear rules. 2/3 for each house, right? And then it's got to go to the states for 3/4. There's no rules for this.
And we argue in the book that there are few mechanisms in public life, fewer legal processes that are more foundational, more fundamental to who we are as citizens in a constitutional democracy. And that fundamental significance of popular authority really is one that should militate against having judicial oversight. And there's a lot of scholarship and relevant precedent that would bolster that. And so there's a real fear here, and we use the term in the book of a true constitutional crisis. If a call were to be issued and you had a moment where there were no rules, you have competing factions claiming the certitude of certain rules, there are likely few fora to resolve those disputes. And that's, by definition, a crisis. There's no way out.
And this idea that there already are enough states to have Congress call a constitutional convention, it's not just anybody saying this. The former governor, you say in the book, you write, former Governor Walker, announced during a Zoom event that there are 34 states and Congress could go right ahead and call it.
The wonders of COVID. Yeah. It was recorded. We saw it. He was speaking to...
he didn't intend for us to see it.
Right. I mean, these ALEC gatherings are often closed door. And this is, Republican state legislatures gather in this nonprofit, in meetings by this nonprofit organization. But he said, look, the threshold has been met, and it's up to Congress. They need to issue the call now. And as Russ said, a resolution was just introduced in Congress to the same effect. And so it's coming down the pike.
Yeah, Senator Santorum said in a similar setting, he said, we've got the weapon, all we have to do is pull the pin. I mean, they're getting ready to pull the pin.
Use the phrase, to get a live weapon in our hands.
That's right. Which is not, constitutional, convention talk, but,
Right. It's quite the claim.
So your conclusion is it's a very real threat. I don't think you'd write a book called The Constitution in Jeopardy if you didn't think it was a real threat. But the other part of this book deals with how you could re-energize or reform Article 5 and make it a more effective tool for improving America. I kind of got a laugh out of this. I noticed you talked about fighting Bob La Follette a couple times in this book. I figured that might have been a Feingold addition to the book.
But he did the Eugene Debs.
But he wanted to, I mean, Bob La Follette was talking about reforming Article 5 back in the progressive era. You're talking about reforming it now. What would the two of you like to see happen, as at a minimum?
Well, La Follette was the main author of a bill that would have done this. It's the same principle that we're applying, not exactly the same, which is you have to have a popular majoritarian element to this thing. So we have a number of proposals. One of them is that in order to get a constitutional amendment, you have to have a majority of the states, popular vote of the majority of the states vote for it, and a popular vote for the whole country support it. So this would require a constitutional amendment to change this. We also are proposing, and you may want to elaborate on this, that you could set the topics, that Congress would be able to make rules and limit the topics.
I think it's important just to lay the table about why it's so important to have the conversation about reform. We talk in the beginning of the book about some of the founding fathers and how they conceived of constitutional amendment. And George Washington really didn't want to go to the Constitutional Convention. And once the Constitutional Convention adjourned, he admitted that the document that came out of it had flaws. But he, in some of his letters, urged citizens to adopt the document, flawed as it was, to adopt it nonetheless, precisely because it could be changed by the people. And so the core thrust of our reforms is to make it such that Article 5 actually can be this mechanism for we the people to reform the constitutional order. It's clearly how the framers foresaw it working. And there have been missteps.
And it was the first constitutional amendment, first constitution basically ever.
Right.
First constitutional amendment provision in history. And yet, it is the hardest one. Of all the countries in the world, it is the most difficult to amend. So, here in Wisconsin, you can amend the Constitution by getting a majority of both houses in over 2 years and then a popular vote of the people. But this one is so difficult that we think it needs to be reformed. Now, one important point here is this would have to be done by Congress by 2/3, because if we had a convention do it, what do we say? It would be they could do whatever they wanted. And you might not end up with anything of the kind. So we think 2/3 of both houses of Congress should do this.
Where does support come for that? Because you have some progressives and liberals who are not paying terribly close attention to this, and you have some conservatives who say, we like it just the way it is, and frankly, we don't want to see the Constitution amended in ways other than what we want.
Right.
Where does the support for these ideas come from?
I think you're totally right. And our view is that we should discuss that. I mean, we should be discussing constitutional change as a first-order question, rather than debating all of the second-order questions about judicial interpretation and different interpretive theories. We should be debating as a society and as citizens, how do we get to these core questions? And I think in terms of support, there's support across the spectrum, I think. Clearly, there's support on the right for having these kinds of debates about constitutionalism. Those on the right might disagree with some of our proposals, but the point is to have the conversation, to actually make constitutional amendment a topic of political debate again. Really has fallen from the front lines within the last 3 decades.
I'm going to ask Senator Feingold one final question. This sort of relates to what you're talking about here. It's a very serious topic, and it feels like we're in a serious moment in this country. So what is your take on the state of our democracy as we sit here today?
Well, it's deeply depressing. Somebody put out a tweet the other day that said, here are the 4 threats to American democracy. And one was the Supreme Court, one was the independent state legislature. And so we emailed each other, well, we're the 5th. But the way I would answer it is, as somebody that had a long political career, when I'm sitting in my house in Middleton, Wisconsin, and I go down to vote at the clerk's office, and I say, how are things going over here in terms of your poll workers? Sometimes the retired people that would do that. They're afraid to be there. And that's a conscious attempt to intimidate people to not even vote, to be afraid to vote. If you're afraid that you're going to get hurt when you go to vote, you're probably not going to vote, or you're less likely to vote. Some people have given their lives to do that, but that's sort of normal behavior. So I think it begins with a grassroots effort to destroy the fabric of respect for our democracy. And this would be one of the true trump cards, forgive me, if they did this. But it is a very deep, very serious, dangerous moment for our Constitution and our democracy. And I wish I could be, I'm sort of a glass half full guy, but it's tough on this subject right now.
I'm going to take a couple of questions from the audience, maybe just a couple here before we wrap things up. Please raise your hand and wait for either Eric, who's over here with a microphone, or Ryan, who's over there with a microphone, to ask your question. Let me see. We'll go right there. 1 second and wait for Eric. He'll get you. And keep it brief, if you would,
Yes,
please.
hello, thank you. How does gerrymandering fit into this scheme? I have to imagine that is a big part of this.
It's enormous. I mean, you might notice that we have a Democratic governor here, and we have a Republican legislature. The governor used to have nothing to do with this. It's only the legislature that gets to vote on these applications. And so you have gerrymandered legislatures all over this country doing all kinds of things, including this. And so it is directly related to gerrymandering.
And it goes back to the foundational question. The preamble begins, the first 3 words, we the people. And the amendment mechanism should be the purest manifestation of popular sovereignty. Yet we have state legislatures in states like Wisconsin, other states that are so gerrymandered that it can be challenging to accept the claim that state legislatures are truly reflecting the belief of the people. And it's a theme that comes up actually a number of times in the book. We use it as an example of how the provision is drafted is flawed and needs reform, and why at the end of the day, Article 5 should be put directly into the hands of the people through popular vote.
Other questions? Somebody's pointing here. Yeah, Ed, sure enough. Hang on 1 second. Ryan?
Thanks. Hi, Ed Falone from Marquette Law School faculty. Welcome back, Senator. Good to see you. If your goal coming here was to scare us, congratulations, you've succeeded. Is there a connection here to some of these more conservative groups who really are attaching the Constitution to their idea of America in terms of our Constitution, not yours, not everyone's, but almost a proprietary sense of our Constitution?
Well, they appear to have that view. They appear to view the Constitution, which, those of us that work at the American Constitution Society, we like to talk about the founding failures of our Constitution, that it was flawed from the beginning. But we get the feeling that some of these folks are perfectly comfortable with the idea that many people were excluded from that Constitution. And that's an error that has been made up for partially, but not completely. So yes, they do have a view that they could redo the Constitution, hardwire the Constitution, in a way that would take us back before the Civil War, more to the John C. Calhoun nullification notions, maybe even back to the Articles of Confederation. This idea of the states sort of separately deciding all this. So it's, I think that is part of their vision, yes.
We, in the introduction, we say, is it not fascinating to read the first line of the Articles of Confederation, which says, forgive me if I make one slight error, but it's like, we the undersigned delegates of the states. Compare that to the Constitution, we the people. Yet the current movement on the right is really animated by a very Articles of Confederation notion. And that is at odds with, large expanse of our constitutional history and our political culture.
We'll take one more question. Gentleman back here, yes.
You talk about this as an issue on the right. I know people on the left who support this, particularly to get rid of the Electoral College and also define corporations not as people. They would support perhaps this. How do you think that plays into this whole issue?
Thank you.
Yeah, we do cover this in the book, and I've attended lectures by Lawrence Lessig, Sanford Levinson, and others who believe that we should roll the dice, who believe that a convention is a place where you could get rid of the Electoral College, overturning Citizens United. I'd like that, based on the work that I did in the past. But, there's an element of sort of recklessness about this because there are no rules, and these folks are going to set this up based on states rather than a general popular vote. I'd be happy if we had a constitutional proposal out for a general popular vote on this kind of thing, but that's not what you'd end up with. And so, but there are groups, and they're well-intentioned. Wolfpack is one group that's trying to do it on campaign finance. Others think we should do it. There may be a day with reforms in Article 5 when that would make sense. We do need to make some changes, but I would say that it's somewhat misguided, and I know we're going to be debating this for months with people around the country.
What do you hope will be the results from this book? What do you hope will be the takeaway?
I think at base, what we hope to do is that Article 5 will become a topic of discussion in the public square, that will begin to think about constitutional change. Like I said before, both its the dangers that surround it, but also the potential, as a first order question that people are debating at the dinner table, at local council meetings. What does it mean to live in a constitutional democracy? And how do we make that real today?
So, buy a bunch of the books and give them to your friends. and if you don't do that, just copy Chapter 5, which is what Trump and the Tea Party couldn't do. If you can read those pages and not get a little nervous, more power to you.
Again, the book will be available out in the lobby immediately after this conversation ends. I want to bring things to a close by taking a moment of personal privilege to ask Peter a question about his family, a number of whom are in the audience today. But I want you to introduce us, and she does not have to stand, but I want you to introduce us to your grandmother, because this is a place of civic education, of lifelong learning. It's a law school. Tell us about your grandma.
Well, my grandmother, Agnes Prindiville, decided at the decided in retirement that she had always wanted to be an attorney, and passed the bar at the age of 81. And now at the young age of 94 continues her legal work. And so it's been such a joy.
Still doing pro bono work, isn't she?
Right, indeed.
Yeah. Good for you.
And so it's been a real joy to share the law with her. Going to law school at my age, and it's been a wonderful kind of cross-generational experience.
An inspirational force in your life?
Oh, indeed, most definitely.
Yes. Anyhow, I'll wrap things up there. Again, thanks for coming here today. It's great to see everybody in person. And we are delighted that we could have Russ Feingold and Peter Prindiville with us today to discuss this new book. Again, it is called The Constitution in Jeopardy, an unprecedented effort to rewrite our fundamental law and what we can do about it. Thanks very much. We'll see you next time. Thank you. Fantastic.